Good morning, everyone. My name is Sylvia Soltis, and I'm the Director of Legal Aid's Pro Bono program. Thank you for joining us for our Pro Bono training on preparing record-clearing motions in DC. Criminal record sealing is more than just a legal procedure. It's a powerful tool for restoring dignity, expanding opportunity, and disrupting cycles of poverty and exclusion. I'm grateful to have your interest in using your legal skills to serve our community. The need could not be greater. We are recording this training. After the training, we'll share the link to this recording to those who have registered. Also, if you have any questions throughout the training, please type them in the Q&A box. We are going to do our best to monitor that, and we're going to answer some of the questions in real time. However, there may be some that we need to hold off until the end of our presentation. Now, there we go. Now, allow me to take a moment to introduce my colleagues who are with me today. We have Amanda Korber, the Director of Reentry Justice Project. We have Becca Gallahue, the Project Coordinator for the Reentry Justice Project, and Shula Bronner, the Legal Assistant in the Pro Bono program. We have a lot to cover today. So allow me to give you a high-level overview of what's on tap. We will begin with a little bit about Legal Aid DC and our Reentry Justice Project. We'll discuss the importance of criminal record sealing, give you an overview of pro bono criminal record sealing cases. We'll review the relevant statutes, including the new law in effect as of March 2025. We're going to give you guidance on interviewing your client, discuss how to draft the declaration and motion, and review what happens post-filing. For those of you who may not be familiar with Legal Aid, we are DC's oldest and largest civil legal services provider. And for more than 90 years, Legal Aid lawyers have provided a continuum of legal services to clients in the areas of domestic violence, family law, housing law, public benefits, consumer law, and more recently, immigration law. In addition to providing direct representation, we also help clients avoid unnecessary legal entanglements through outreach and education, and we often help them with advice and brief services. We also work to identify systemic issues that have an impact beyond just the individual client. Our pro bono program allows us to expand our impact excuse me, in the DC community by providing legal assistance and representation to hundreds of additional families and individuals each year in almost all of our practice areas. It is through our partnership with attorneys just like you that we can help more people. Our Reentry Justice Project began as an in-house project in 2015, understanding that individuals who have interacted with police and the criminal justice system find themselves facing a multitude of collateral civil consequences that act in real and concrete ways to perpetuate generational cycles of poverty. Our work has focused on both direct representation and broader advocacy for systemic change. Indeed, the passage of the Second Chance Amendment Act, the new law that we'll be diving into today, is an example of our systemic efforts. This new law was desperately needed to reform the district's outdated and restrictive criminal record legal scheme. Over the course of the last decade, the Reentry Justice Project has been dedicated to supporting individuals who face barriers to housing, employment, education, and other essential opportunities, simply because of a past interaction with the criminal legal system. Now, these barriers are not abstract. They're deeply personal, deeply unjust, and deeply entrenched. The work you'll be trained on today, criminal record sealing, is a vital part of our Reentry Justice Project's mission. It is about giving people a real chance to move forward and rebuild their lives without being permanently defined by their past. Oop. I think I just skipped a slide. There we go. The impact of criminal records fall disproportionately on communities of color and individuals living in areas of concentrated poverty. In DC, the statistics are stark. And while there are a few different statistics on this slide, the one I really want to highlight for you is the third one. Black individuals make up less than half of the district's population, but in 2021, they comprised 85% of those arrested and 95% of those serving prison sentences for DC code violations. These numbers tell a clear story about systemic injustice, and they underscore the urgent need for this work. This project matters because record sealing helps clients helps them reclaim access to employment, housing, and stability. But beyond the tangible benefits, the work restores dignity and hope. Every motion filed, every record seal is a step toward correcting an inequitable system and giving someone a true second chance. If you've never taken a pro bono case from legal aid before, allow me to briefly outline what our process looks like in our criminal record sealing matters. As individuals come to legal aid seeking criminal record sealing relief, we conduct interviews to learn more about the person in front of us, their criminal records, and the ways in which those records have held them back. During our screening process, we obtain documents such as police history reports, court records, and any other relevant documentation to make an initial eligibility determination. Once we've reviewed the materials, and determine that the client is eligible for relief, we share a brief case description with you or your firm so you can learn more about the prospective client and the records they are seeking to have sealed. Once you let me know you're interested in a case, I can then share conflicts information with you. You would then be responsible for letting us know when you've cleared conflicts and received all necessary internal approvals. And once that's complete, I can then share all client materials and contact information for the prospective client. With every referral we make, we will share with you the case documents, training materials, sample motions, and introduce you to your legal aid expert mentor. Your legal aid expert mentor is there to answer questions that go beyond our training materials. They are there to review your final draft. And I want to be clear now, as helpful as our mentors are, I do want to flag for you that they are not co-counseling the matter with you. And we recognize our practice areas may not be your practice areas. So we are happy to offer support and guidance in your pro bono referrals. Now, with that, and a little bit more background of how this process works, I am going to turn things over to Amanda Korber, who may very well be one of your mentors when you take on a case, to share more about the workflow once you've accepted the pro bono case referral.
Thanks, Sylvia, and thank you everybody for being here. So once you've received your referral from legal aid, there are a few things you're going to want to do. The first is review your client's criminal records, review all the materials you've gotten from legal aid, which as you'll see later on, I think we're going to talk about this, is going to include a lot of their court documents. Just familiarize yourself with what their record looks like. The second thing you're going to want to do is a really important step. You're going to want to call your client, introduce yourself to your client, and then most importantly, interview your client. And we'll talk a little bit more about what these interviews entail, but this is the point where you get to know your client, you get to know their story, and this is kind of the heart of what your motion is going to be, the information you get from talking to your client and finding out about who they are, what their hopes are, and why they want their records sealed. After you do that, you're going to draft a declaration that tells your client's story. After that, you're going to draft one or more record clearing motions, depending on what types of records are on your client's record. Then you will file your motion, and then you will likely await a decision from the prosecutor, a response from the prosecutor, and then a decision from the court. And so we'll talk a little bit more about all of those steps in detail on the slides to come. So Sylvia, if you can go to the next slide. The types of motions you might be preparing are varied, and like I said, are going to depend on your client's record. And we'll go over each of these types of motions later on in more detail. But you might be moving to seal arrest records, meaning records that are non-convictions. You might be moving to seal records of misdemeanor convictions and eligible felony convictions. You may be moving to seal records for fugitive from justice cases. You may be moving to file convictions under the Youth Rehabilitation Act, which is a DC law that allows folks who are convicted of crimes that they committed under the age of 25 to have those convictions set aside. And you may be moving to expunge arrest records on the grounds of actual innocence. In some cases, your clients are going to need one or more of these motions, and you may need to file sort of one motion that covers all of these or one or more of these areas, and we'll talk about that more down the line. Next slide, please. And now I'm going to turn this over to Shula, who is going to talk to you a little bit about what you'll get once you accept a referral from legal aid.
Thank you so much. So as Sylvia previewed, when we share the full referral with you, you'll receive contact information for the client and also a case description, which includes the client's arrests and convictions and our analysis of their eligibility for each arrest or conviction. We'll also share various court documents, including certified dispositions for each case, the case dockets, and where available, court documents from the case. There are not always court documents. Often they're not available if the case is very old or if it was dismissed very quickly, but we'll share them if they're available by public access. We'll also share an arrest history from the Metropolitan Police Department, MPD, that lists all of their arrests in DC. In some cases involving a conviction, you might also receive a letter from the Court Service and Offender Supervision Agency, which outlines that the client has completed the terms of their sentence or completed the terms of their probation. You might not always receive this. It is a rather arduous task to get this letter from CSOSA and can take many months. So while it can be a beneficial exhibit to show that they've completed the terms of their sentence, we might have made the assessment that it is not essential. But if you, upon your assessment of the case, decide that you would like to collect this letter from CSOSA, we will guide you in that process and provide instructions for how to do so. And then lastly, we'll also share template motions for each type of record clearing motion you're asked to prepare, including combination motions. I'll now pass it over to my colleague, Becca Gallahue, to share more.
Thanks, Shula, and thank you all for being here. Next slide, please. I'd like to talk a little bit about the difference between the terms expungement and record sealing. Oftentimes they may be used somewhat interchangeably, in DC, and these terms actually mean something very different under the laws. It's kind of it may go to say that there's also differences kind of state by state or jurisdiction by jurisdiction about how they define expungement. For the purposes of this training, we'll just be talking about how DC views expungement versus record sealing. Expungement effectively erases the criminal records while sealing removes public access to those criminal records. A former colleague of ours used to use this great analogy that really helped me understand the difference, so I'd like to share it with you all. The way she put it is that expungement is like putting the records into a shredder. Those records become, kind of distorted, in pieces. It's not something that somebody can easily kind of take a look at that record and see, what's gone on in that case. They're effectively destroyed. Maybe a little bit of an oversimplification here, but I think it's a really good analogy there. Whereas sealing is the equivalent of putting those records into a lockbox, and only certain agencies or certain entities have the key to that lockbox. So that can include, prosecutors, law enforcement agencies, licensing agencies, licensed daycares or schools, and a few others. Understandably, most clients or applicants, when they're coming to legal aid, what they're really hoping for is record expungement. Understandably, these records have, held them back for some time, and destroying the records or not having them, kind of exist at all is kind of the gold standard. While the Second Chance Amendment Act does expand, expungement a little bit, record sealing really is the relief that's available in most circumstances for most cases in DC. Unfortunately, the law change, didn't drastically expand expungement. There are some statutes outside of the Second Chance Amendment Act. For example, there's a human trafficking act that allows for vacating and expunging, records and convictions that are linked to human trafficking. However, again, expungement is kind of more, it's available in more limited circumstances. We'll talk a little bit about it shortly about kind of one area where the Second Chance Amendment Act does expand it. Next slide, please. Right. However, there are, protections available to clients, to folks when they've had their records expunged or sealed when it comes to disclosing those records. So once an individual's criminal records have been expunged or sealed, that person does not have to disclose the citation, the arrest, charge, prosecution, disposition, or conviction. And so somebody can truthfully answer no if they're asked about convictions or arrests on a job application or another type of application, maybe like a housing application for rental housing, if records of the convictions or arrests have been expunged or sealed. Additionally, the individual can deny any arrest or conviction that has been sealed or expunged in response to any inquiry made of them for any purpose. So it is important for clients to know, even if a record can't be expunged, there are protections for folks, again, regarding disclosure of expunged or sealed criminal records. And I'll turn this back over to Amanda Korber.
Now we're going to jump into an overview of some of the substantive provisions of the Second Chance Amendment Act. So the first thing we're going to talk about is what Becca referenced, an area where the Second Chance Amendment Act expands expungement. And so one thing the Second Chance Amendment Act was provide for automatic expungement of records of simple marijuana possession and decriminalized offenses. And so the word automatic here is obviously very important. What that means is this isn't by motion. So these are not necessarily cases that you will be involved in or get referred from legal aid, but it's still important to know that this exists. So in these cases, the court will automatically expunge simple cases that were for simple possession of marijuana and for decriminalized, legalized, or offenses that have been held unconstitutional by the court. The one catch here is that the deadline by which the court has to automatically expunge these records is not until October 1st, 2027, or within 90 days after the termination of the case, whichever is later. So what that means is for folks that have these now, they have a bit of a waiting period before the court is going to automatically expunge these records. Next slide, please. Another area, so this is about sealing, not about expungement, but it is another area where the relief will be automatic and doesn't require a motion, is the automatic sealing of records of non-convictions and misdemeanor convictions. So what this relief provides for is that the court is required to automatically seal criminal records of arrests and misdemeanor convictions, with the exception of a list of certain types of crimes that are not eligible for automatic sealing. And I believe that list is on a future slide, so you'll see which ones are not eligible for automatic sealing. But as long as a person's arrest or misdemeanor conviction is not on that list, their records will be automatically sealed by the court. Again, however, there's a bit of a waiting period. The court has until January 1st, 2027 to seal those records. So I'm going to highlight now a potential gap in the current law, though I do want to flag that it's not something that pro bono attorneys are going to have to worry about because we won't be referring these sorts of cases to you, at least for the time being. So as I mentioned, these cases that are eligible for automatic expungement or automatic sealing, there's a waiting period before the court actually has to do that automatic expungement or automatic sealing. And there's no statutory provision, unfortunately, that explicitly allows for these records to be automatically expunged or sealed by motion prior to that date. So as you can see, that creates a problem for folks who have these records, who want them off their record now as opposed to in 2027. Legal Aid is thinking about that issue, working on that issue, and we hope to have a solution to it in the near future, so folks don't have to wait any longer to get those records sealed. But I just wanted to flag it for you. So we can now move on to the next slide, please. So now we'll talk about motions to seal under the Second Chance Amendment Act. And so this is where you all come in. So this is not automatic sealing or expungement like I was just talking about. These are cases where clients are allowed to and are going to file motions asking the court to use its discretion to seal their criminal records. So let's talk about the different types of motions you might be asked to file. They may be asking to have their arrests sealed by the court. Folks may be asking to have their misdemeanor convictions or eligible felony convictions sealed by the court. For convictions that are eligible for sealing, there are waiting periods that depend on whether it's a misdemeanor or a felony, and we'll talk about that in a little bit. And then there are specific provisions for folks who want to move to seal arrests in fugitive from justice cases, which we'll also go into more detail on in just a few minutes. Again, I think I said this earlier, but it's important to note that the court has discretion to decide whether or not to seal these records. And so that's why, as I mentioned earlier, your kind of conversations with your client where you find out about their history, their story, who they are, and why they need their record sealed is going to be really important, because that's the information you're going to use to convince the court to use its discretion to give your client the relief that they need. Next slide, please. Okay. So let's start off talking about sealing non-convictions under DC Code 16806. And so under DC Code 16806, a person can move to seal non-convictions as long as that non-conviction is on the list of offenses that is included on this slide. And I will say that there are a lot of different types of potential offenses that could fall into this category. The ones we most often see are arrests for dangerous crimes, arrests for crimes of violence, and arrests for driving under the influence. And so I would say those are the most common types that we see and that you might see in a referral. Next slide, please. The next type of motion under 16806 that you might be asked to file is a motion to seal records of misdemeanor and eligible felony convictions. So as I mentioned earlier, for each of these types of motions, misdemeanor or eligible felony convictions, there is a waiting period. So for misdemeanor convictions, folks have to wait 5 years after sentence completion to have their misdemeanor conviction sealed, or I should say to move to have their misdemeanor conviction sealed. And folks need to wait 8 years after they've completed their sentence to move to have their felony conviction sealed. And I want to note that sentence completion means that we're not talking about 5 or 8 years from when they were arrested, from when they were charged, from when they were convicted. We're talking about 8 years from when their sentence was over. That includes things like from when their probation ended. A really important change under the Second Chance Amendment Act from the old law, that some of you may be familiar with or maybe took cases from us under, is that a person doesn't have to wait for everything on their record to be eligible for sealing in order to ask the court to seal. So what that means is if a person has a misdemeanor conviction that's eligible for sealing today because it's been 5 years, but they have a felony conviction that isn't eligible yet, or vice versa, or if there's something else on their record that isn't eligible, it's okay, because they can move to seal the thing that is eligible and wait to seal the thing that isn't eligible until the future date when it is. And the other thing I want to note is that the reason it says eligible felony convictions is because there are some felony convictions that even under the new law are never eligible for sealing. That includes things like murder, sex abuse, armed burglary. Those may never be sealed even under the current law. Next slide, please. Okay, so another type of motion that you may be asked to seal, may be asked to file, is a motion to seal records for fugitive from justice arrests. So these are cases where folks have warrants in other jurisdictions and they get picked up in DC. In these cases, the judge has discretion to seal these records if the individual was arrested in DC as a fugitive from justice, waived their extradition hearing, the case was terminated by the prosecutor or otherwise reached a final disposition, and the individual demonstrates by a preponderance of evidence that they appeared before the proper official in the appropriate jurisdiction. So meaning that they appeared where they were supposed to appear. And the only other thing I'll add is that, as we'll talk about in a few, all of these motions require that your client convince the judge that it is in the interest of justice to seal their arrest record or their conviction record. Next slide, please. Okay, so the procedural requirements for motions to seal under DC Codes New 16806. An individual who wants to get relief under DC Code 16806, so that's all these motions that we've been talking about, has to file a written motion that explains all of the individual's unsealed and unexpunged arrests, charges, convictions to the best of the person's ability, an explanation of how the arrest or conviction records satisfy the eligibility requirements that we just talked about. So things like, just explaining how the waiting periods have passed, how if it's an arrest, it's on that list that we were talking about, things like that. And then finally, facts in support of your client's motion. So, and that's what I was just mentioning, that the motion has to demonstrate that by a preponderance of the evidence, it's in the interest of justice to seal their records. And that's really where the meat of the motion is going to be the most important part of your representation and of your written work product. Next slide, please. So the interest of justice standard is laid out in the code. So the court has to consider three things: the interest of the person filing the motion in sealing the publicly available records of their arrests and convictions, the community's interest in furthering the movement's, your client's rehabilitation, and enhancing their reintegration into society through education, employment, housing, and the community's interest in retaining access to the criminal records. And so we'll go into on the next slide what factors kind of make up these three different prongs. So the court may consider, when looking at these three prongs, things like the nature and circumstance of the alleged crime, the role that your client played in the alleged crime, your client's history, including their character, physical and mental health, their employment history, past substance abuse issues, dependence, and also like treatment opportunities that they've had since then. The other, the kind of their criminal history in total, how long it's been since they've had involvement with the criminal legal system, your client's efforts at rehabilitation, and as I mentioned, the time that has passed since the offense that you're trying to seal, and also, any other factors that the court may consider relevant. So anything, if you're talking to your client and you think it sounds like an important fact that the court would want to know, you should absolutely include it in your motion. Next slide, please. I'm now going to pass this over, or I should say back to Becca Gallahue, who's going to talk a little bit about motions to set aside convictions under the Youth Rehabilitation Act.
Thanks, Amanda. So I'd like to talk a little bit about the discretionary setting aside of convictions under the Youth Rehabilitation Act, or the YRA. This is not part of the Second Chance Amendment Act. This has already been in place. But under the YRA, a court has the discretion to set aside convictions for offenses that occurred when somebody was under the age of 25. And so it's really important to note that for somebody to be eligible for the YRA, the offense at issue has to have occurred when the person was under the age of 25, 24 or younger. So that could mean the offense at issue occurred the day before somebody's 25th birthday. They're arrested on their birthday or the day after, or something along those lines. And then a court case is filed, shortly thereafter. That would still be eligible for a set aside if the person was eventually convicted because the offense at issue happened, before the person turned 25. So it's not based on when they were arrested or when a case was filed against them. It's important to note that there are certain types of convictions that are not eligible for a set aside. Those are convictions for murder, first and second degree sexual abuse, first degree child sex abuse, for example, those may not be set aside. However, on the list of the cases that are not eligible for, for the convictions that are not eligible for sealing that Amanda talked about, there are 3 types of convictions that are eligible for a set aside under the YRA, that are not eligible to seal those convictions through the Second Chance Amendment Act. Those are armed burglary 1, carjacking while armed, and assault with intent to kill while armed. It's also important to note that the court can set aside a conviction. Somebody can be sentenced under the YRA. And so upon successful completion of the sentence, the court may, discretionarily decide to set aside that conviction. Or it could be something where the person is not sentenced under the YRA, or they do not, the court terminates kind of or says that the person completes the sentence without the benefit of the YRA. And at a later date, they can move to try to set aside that conviction by motion. So we see here, it's a successful completion of the sentence for that offense is an eligibility requirement. But again, that doesn't mean, if you are looking at a referral from us and you see that, somebody was sentenced under the YRA 10 years ago, the court decided to terminate that case without the benefit of the YRA, it doesn't mean that you can't move to try to set it aside now. It doesn't mean that somebody has to have a, flawless probation record if they were sentenced to probation. The biggest thing, though, is that they do need to have completed the terms of their sentence. So somebody cannot try to set aside their conviction, for example, if they are still on probation or supervised release for that offense. Next slide, please. There are some factors that the court can consider when deciding whether or not to set aside that conviction under the YRA. So it can be the person's age at the time of the offense, the nature of the offense, including the extent of the person's role in the offense, and whether or not an adult was involved. So in terms of adult involvement, it could be maybe there is an older co-defendant, or it could be that there is an adult in the person's life where they were exerting a lot of influence or had a lot of influence over that person. And there is a connection between that adult's influence and the the alleged crime or the conviction at hand. Another factor is the person's compliance with the terms of their sentence. We talked a little bit about that before. The person's criminal history, family and community circumstances at the time of the offense, including any history of abuse, trauma, involvement in the child welfare system, physical, mental, or psychiatric health, the use of drugs or alcohol, and the person's history and capacity for rehabilitation. Okay, next slide, please. Thank you. So we definitely want to discuss the effect of setting aside a conviction under the YRA. So it's important to note if the court grants a motion to set aside a conviction under the YRA, all of the records of the conviction will be sealed. So I want to use a practical example or a concrete example here. So when it comes to how the DC Superior Court treats convictions that are set aside under the YRA, they will move information about that conviction, about that case, to a non-public file, meaning if you were to look on the e-access or court view, the docket search system for criminal cases in DC, if a case has been set aside under the YRA, that case will not come up on that when you do that docket search, just the same way that a sealed or expunged case would not come up. However, it is important to note that information about the arrest for a set-aside conviction can still show up in various places for for somebody who has had a conviction set aside. Again, to use kind of another concrete example, we've certainly had clients come to legal aid saying, many years ago I was sentenced under the YRA. The judge set aside my conviction when I completed the terms of my sentence, and yet I just got a background check trying to get a new job, and it's still showing up. Information about this case is still showing up. I don't, my understanding was that this case was supposed to be sealed or expunged, and so information about that arrest can still show up on a background check, an FBI background check, for example. And so in those instances, we're looking to see what other forms of relief through the Second Chance Amendment Act, could be available for somebody. A conviction that's set aside may still be used in subsequent prosecutions for enhancement and sentencing, and may also be used for certain other limited purposes, according to the DC code. And so set aside convictions really can only be considered very, in very limited circumstances. But still, again, important to kind of know what relief is available under the YRA and what relief, is not available through a set aside and sealing. We can certainly discuss with your mentor whether or not there may be options for sealing. I'd also like to talk about motions to seal arrests on the records on the grounds of actual innocence under 16803. For those of you all who have taken cases or who are familiar with the statute, here it's very strange to be talking about 16803 regarding actual innocence, because 803 used to kind of be more of the standard sealing statutes. But now it's important to know that when we talk about 803, we're talking about actual innocence. And so again, this is discretionary. It's the court may order the expungement of criminal records, citations, arrests, or charges on the grounds of actual innocence under 16803. Again, this is not it's not available for folks who were convicted of an offense. It's only available for non-convictions. And it is something where somebody will have to file a written motion. There is not an option for automatic expungement under actual innocence. However, the written motion can be filed at any time. Somebody has to demonstrate, though, by preponderance of the evidence that the offense at issue either didn't occur, and so no crime was committed, or if an offense did occur, it was not committed by the person filing the motion.
Okay, now we're going to move on from the substance of the law to kind of turning back to your role once you take and get a referral from legal aid for one of these cases. So as we mentioned earlier, in many ways, the most important part of your representation is going to be your conversations and your interviews with your client. So I'm just going to go over some best practices for both preparing for and then actually having those conversations and interviews with your client. So the first thing is you're going to want to, before kind of having your first meeting with your client, to really dive into the substance of your case. You're going to want to sit down, look at the statutory factors that the judge has to consider, or that the judge may consider, and prepare an outline that covers the different bases that you want to explore with your client. Once you do that, you're going to want to either schedule or have your first meeting with your client. I think pro bono attorneys do this different ways. I think some pro bono attorneys and some clients like to meet in person. Other times, folks, either because the client can't meet in person or doesn't want to meet in person, will have these conversations via Zoom. I do think that to the extent possible, the ability for you to kind of sit face to face, even if it's over a computer with your client, is really important, because you're going to be asking your client about some really hard times in their lives. And so to the extent they can kind of see your face while they're doing that, I think that's really important, and will make for a better experience for both of you. I always like to start out talking to my clients by asking, pretty basic questions, getting to know them, what they're like, what they like to do, how they like to spend their time, before sort of diving into asking them about the specific crimes on their criminal record. It might seem basic, but when you're talking to these folks, when you're talking to your clients, be friendly, be warm, talk to them like you would talk to a neighbor or a colleague, be respectful. But also, it doesn't have to be super formal or super planned. We talked about having an outline, but it really should be an outline for a conversation that you want to have with your client, just to make sure that you kind of hit all the information you want to hit, not that you have to stick to it, and make sure you ask, check every box. Pay really close attention to what your client says to you. It's important that your client knows that you're listening to them, that you're hearing them. And obviously that's the most important reason to pay close attention to what they're saying. But you also want to pay close attention to what they're saying, because what your client is telling you is what is going to make up the majority of the motion that you write. The story that they tell you is the story that you are going to then tell the court. And so you're going to want to take really good notes. A lot of times while I'm talking to my clients, they'll say something that catches my ear, say a phrase, a quote, some sort of motto that they live by. And I'll just like honestly write it down word for word, because the more you can put their own voice into the motion and the declaration, I think the better. It makes for a richer, more compelling case for the judge. Next slide, please. This next tip also might be seem kind of basic, but I think it's really important. Ask follow-up questions. If something that your client says either you can't quite make sense of, ask them questions so that you understand what they're saying. But also if they say something and it just sounds really interesting and you want to know more, ask follow-up questions, probe deeper. A lot of times it's those like details about what they are telling you that make for the most compelling motion. And of course, your client, and some clients aren't particularly forthcoming. It could be for a variety of reasons. Some folks are shy, some folks just aren't chatty. And some folks, they're kind of talking to somebody they just met about some of the hardest moments in their lives. And so in those cases, it's even more important to kind of go back to what we talked about earlier and ask kind of icebreaking questions, what their days are like, what their weeks are like, what their life is like, before diving into the more difficult to talk about things you want to discuss with them. If you notice that your client is having a hard time or struggling about talking about certain things or moments that have happened in their lives, just take a break, slow it down. You can always regroup another day and give them time to kind of process. We certainly have to do that often with our clients. Sometimes people will explicitly tell you, like, I'm kind of spent for today. I can't talk about this anymore right now. And in that case, obviously, you should agree that you'll kind of find another date to continue the conversation. But also, if they're not saying that explicitly, but you're noticing that like kind of they're just having a hard time talking about certain things, it might be a good thing to suggest. Next slide, please. Okay, I think I am turning it back to Becca now. Yeah, okay, great.
Thank you. So now we'll talk a little bit about drafting the actual declaration and motion papers. We'll start by talking about drafting the client declarations and best practices there. Although I do want to note, while we talk about drafting the declaration before the motion for the purposes of this presentation, some folks absolutely prefer to draft the motion first and then go to the declaration. Whatever works best for you. Keeping in mind for both, motion and declaration, but we'll talk about the declaration here, that you have over the course of the interviews that you've conducted with your client, you've gotten to know your client a little bit better. You've gotten to understand why record sealing is so important to them, or having their record, sealed or expunged would make a difference in their lives. Remember that the court is going to be, reading the motion. And because these motions really most often are decided kind of, on the papers, where there's not going to be a hearing, it's important to put forth a persuasive client story that also demonstrates why the client merits the relief requested. And so when it comes to the declarations, there's no need to write, an extremely long declaration. It can be, a little bit on the shorter side, as long as it again is compelling and telling that client's story. It should be told in the client's voice. So again, if you've taken down some quotes, from the interview, it's a good time to kind of incorporate those quotes and be writing the declaration in the client's own voice. And writing like kind of using the I statements and having the client will eventually sign that declaration. Focus on concrete facts, so such as job opportunities that were lost, programs completed. It is really important by focusing on those facts. Again, you're helping tell that persuasive story versus if you're using a lot of vague terms or adjectives like growth or transformation, that doesn't tell as compelling of a story. So for example, a client may wish to show how they have grown through courses that they've completed. Maybe shortly after their last interaction with the criminal legal system, they decided that they really wanted to go into the field of, information technology. And so they ended up taking a course in information technology and have been looking for that job in that field, but have been unable to find it. And they're concerned that this record that they have is holding them back. That's a really good concrete fact that helps demonstrate why the client should have their records, sealed or get this record released. Write the declaration in a logical and chronological way, again, keeping in mind that the courts and the prosecutors are going to be reading it, and so they want to be able to kind of follow along in the declaration, what your client is saying. And then lastly, do double check all of the facts. The declaration will be signed by the client under penalty of perjury, so it's really important that it is an accurate declaration that they're putting their name to. And so having a chance to, again, meet and go over the declaration, either over, Zoom, phone, in person, gives the person the chance to kind of go through and say, yep, no, this all looks good, or hey, there's a couple corrections or changes I think we'd like to make. That wasn't quite what I was saying. So after you've completed the interviews with the clients, you will prepare a draft of the declaration. You can use the template motions for the actual motion when you're writing it. In terms of looking at a declaration, sometimes we know firms have internal samples. So you may want to ask if somebody at your firm has taken this, has taken these cases before, whether they have sample declarations. We may have one that's available, although it's still TBD because it was written under an old statute that no longer applies. When you're drafting the declaration, you might figure out or discover that you need additional info from the client, which is absolutely fine. You'll have a quick follow-up conversation with the client if necessary. When I've helped attorneys with these motions and declarations before, I have let folks know after kind of our longest or longer interview that, hey, I may need to call you back. It's probably pretty likely just to kind of fill in the gaps here. That way your client knows to expect, a phone call or a follow-up email or text message, from you to be able to kind of fill in, again, those missing pieces. Ask the client then to review the declaration, again, that we talked about. It's under penalty of perjury, and so we want to make sure that the client has the opportunity to review. You can let them know that it's near file, but there may need to be a few additional tweaks or changes before execution and filing. And then making clients, if the client suggests changes, making the changes that the client suggests, with kind of one maybe exception. If you're unsure about a change suggested by the client, you can ask your legal aid expert mentor for guidance. One example is if you think that the change to the declaration could be seen as relitigating the facts, the underlying facts of the criminal case. And unfortunately, particularly if you're filing a motion under 806, for example, it is not the appropriate forum within the court to be relitigating those facts of the case. And so we could also expect and have seen before sometimes when the government thinks, the prosecutor is thinking that you're trying to relitigate those facts, and they may object to that motion. And so, again, if you have concerns about those suggested changes, do feel free to ask your expert mentor for guidance, because we're happy to help folks walk through and explain, any risks to the client, or talk through ways to maybe rephrase what the client is trying to suggest through their change. All right. When you're drafting and finalizing the motion, you'll also want to gather and organize the exhibits you plan to file with the motion. So the declaration is, the way we usually do it is the declaration is Exhibit A, client's arrest history from the MPD, Metropolitan Police Department, is Exhibit B, and then the rest of the exhibits can be in any order. So you may have that CSOSA, letter of completion of probation. You may have letters written on behalf of your client from, perhaps somebody who knows them well. It could be a former or current employer, somebody who's a mentor or a mentee of your client, for example, as to why their record should be sealed. That can certainly be used as an exhibit, perhaps certified dispositions or certain court records as well. You may want to be citing to those. When you're drafting the motion, again, if you're drafting it after the declaration or before, you want to use the template motions as a starting point. And you want to show how the facts of the client's case warrant the relief requested. It doesn't have to be a super, super long motion. Again, being succinct and persuasive, is important and good. So you want to write a compelling narrative on behalf of your client, but you can you don't have to write the novel again, as long as you're kind of hitting those important factors that apply to your client's case. Right. Final review and filing. So when you're completed, you may send the completed motion with all of the exhibits, including the declaration, to the assigned legal aid DC expert mentor for review. You may do that. We definitely encourage it for folks who are new to this practice. However, we understand that there are some of you all who have taken many motions. The law has changed, and so you may want to be sending them to us again for review, given the law change. But we know that there are some folks who have taken a number of record sealing cases and become more comfortable there, and may wish to go through internal review channels with internal mentors instead. Once it's finalized, you can have the client review and sign the declaration, and then you'd file the motion, most often on the Case File Express e-filing system. There are some times when you'll need to actually email the motion to the DC Superior Court SEAL team, the division of the criminal court, the employees who work on these record sealing cases. Our manual goes into a little bit more detail there when that's appropriate. Make sure the version of the motion you're filing with the court, though, is in compliance with DC Superior Court Rule 49.1, which talks about kind of privacy protections for filing. And so that should have, social security number should be redacted, client's date of birth, home address, child's name. That information does not need to be included. You can have and should keep an unredacted copy of the motion and exhibits, but keeping in mind, especially an MPD arrest history is going to have all three of the things we just talked about, address, date of birth, and social security number. And so making sure that is in fact redacted. The unredacted copy is kept, sometimes you will hear from the prosecutor, or you may pretty often hear from the prosecutor that they would like an unredacted copy. And so you can send them the courtesy copy then. Filing under seal, most of the, most, if not pretty much all of these cases, you'll want to try to file under seal, because it does contain personal and private confidential information, particularly when it comes to talking about clients' possible histories with substance use or misuse, or domestic violence. Again, our manual talks a little bit more about certain regulations or rules in court when cases have to be filed under seal. But we do, encourage where possible to try and file under seal as well, so that it doesn't show up, the motion doesn't show up in the public docket.
Okay, so you filed your motion now, and what happens next? Next slide, please. So after you file your motion, the most likely next step is that the court is going to order the government to respond to that motion and set a deadline by which the government has to respond. In our experience, these motions are almost always decided on the papers. Hearings are very rarely scheduled, and I could say I've never had a case have a hearing. Sometimes the government will file a response stating that it doesn't oppose the motion, and that is obviously best case scenario. It makes it very easy for you. It also makes it very easy for the court to render its decision. It's also possible that the government will file a response opposing your motion for sealing. So if that's the case, you can check with your legal aid mentor. It's likely you'll want to file a reply, and we can talk through what that means and what you might want to say in that reply, depending on the basis for the prosecution's opposition to your motion. Once the government's response is in, the court will issue a decision on your motion, or should issue a decision on your motion. The new law says that the court will issue its order no later than 180 days after the motion is filed, unless there exists good cause for delay. you know, we don't, because the new law is so new, we don't know if the court will stick to this 180 days or say that there's good cause for delay. I suspect that that will be the case because we do often see cases take longer than 180 days from start to finish, unfortunately. But that's just something that remains to be seen. And then another important thing to note is that there is no set timeline for the court to rule on motions to set aside convictions under the Youth Rehabilitation Act. Next slide, please. So if the court grants your motion to seal or expunge criminal records, they're going to issue an order. Importantly, that order is going to require every entity that has access to the criminal records to seal or expunge those records, provide a certification within 90 days of the order confirming that the records have been sealed or expunged, and answer in response to any public inquiries about the record that no such record exists. As to the second element here, the providing certification within 90 days of the order confirming that they've sealed the records, I will say that we very rarely see compliance with the 90-day requirement from all of the required agencies. Oftentimes we have to follow up with the SEAL team at the DC Superior Court, this team that Becca mentioned earlier, and then they kind of go to the agencies and try and get them to give the certifications that they're required to turn over. And so it does often, in our experience, take longer than the 90 days, unfortunately. So I just wanted to flag that. The other thing the order will do is mention or state that the client does not have to disclose the arrest or conviction that has been sealed or expunged in response to any inquiry made of them for any purpose. Next slide, please. For orders granting a motion to set aside a conviction under the Youth Rehabilitation Act, again, because the relief is slightly different, the order is also going to look different. So what that order will likely say is that the set aside conviction must be removed from public view. It can only be used for limited purposes, and those are the purposes that Becca mentioned earlier in our presentation talking about the Youth Rehabilitation Act. The third thing is that the client will receive a certificate of set aside. And again, similar to the certification issue, we often have clients that don't actually end up getting certificates of set aside. I actually was talking to Becca recently, and I was saying how I had never actually successfully seen one, and Becca was saying that she actually has seen one just recently. So that was exciting news. So maybe it's something that we'll start seeing more of, but that is just an area where what's on the paper might be slightly different than what happens in practice. And then the other thing that's in the order, again, is that the client does not have to disclose the set aside conviction on employment, housing, education, or related applications. And again, as Becca talked about during her presentation, there are narrow, limited exceptions to that rule about not having to disclose the set aside conviction. So with that, I think I'm turning it back to Sylvia, maybe to wrap us up.
Yep, that's right. We are now concluding, and I want to thank you again for joining us today and for using your skills to make a meaningful impact. I really hope this training is giving you a clear sense of the legal steps involved in record sealing in DC, and just as importantly, the human impact behind every case. What may seem like a routine paper filing can truly be life-changing for a client who has spent years feeling defined by their past and shut out of opportunities. And I'm going to be real with you. I know that it can feel daunting at times to jump into something new. And so I want to remind you that we are here and you are not alone when you take on a case referral. While we're not co-counseling with you, we are here to support you with resources and mentorship, our training materials, the video, the manual, the sample materials. They're all here as a reference for you, and we're always happy to answer questions that go beyond our training materials. So thank you, and I truly hope you will be interested in moving forward with a criminal record sealing pro bono referral from Legal Aid DC.